A core value on which the European Union is founded concerns the rule of law. The rule of law means that law is the basis for exercise of public authority. No one is above the law. Everyone must respect the law, also the government, also big companies. Everyone is equal before the law. In the European Union, that means the member states and their citizens are equal before union law. You can defend your rights in court. The legislature of the European Union, being the European Parliament and the Council of the European Union, have adopted a legislative act in which the value of the rule of law is further concretized in principles. The first principle concerns legality. That means that all rules must be made in a transparent, accountable, democratic and pluralistic lawmaking process. There must in addition be legal certainty, meaning that the rules must be clear and precise so that citizens can know their rights and obligations. There is the prohibition against arbitrariness of executive powers, of executive action. The administration must decide in a fair way, not arbitrarily favoring ones and disfavoring others. There must be effective judicial protection, including access to justice, justice delivered by independent and impartial courts, which also defend the fundamental rights of the citizens. There must be separation of powers, that is the separation between legislative, executive and judicial powers. And finally, non-discrimination and equality before the law need to be assured. The rule of law as a core value should be seen together with the other two core values, democracy and respect for fundamental rights. Democracy is the process by which representatives of the people make the laws. In the European Union, it's the European Parliament at parliamentary majority and the Council of the European Union, in which the member states are represented, deciding with a qualified majority, 55% of the member states, representing at least 65% of the population of the European Union. The laws so made are being enforced as the rule of law, provided that these laws are compliant with the treaties on which the Union is founded and with the Charter of Fundamental Rights of the European Union. That is the third angle of this triangle of core values, the fundamental rights which protect the people against any exercise of public authority. Therefore, democracy, rule of law and fundamental rights are an unbreakable triangle which reinforce one another mutually. Let's now look at the rule of law through real-life stories. The Court of Justice of the European Union, based in Luxembourg, is the judicial institution of the European Union, which interacts with the national courts in interpreting, applying and enforcing union law, so that union law be the same everywhere in the 27 member states of the European Union. The Kraaienest case concerns a story about polluted air in the Brussels capital region of Belgium. Lies Kraaienest and some fellow youngsters of the Brussels region, together with the NGO Client Earth, they posit that there is too much nitrogen dioxide, NO2, in the Brussels air. Brussels should locate the points to measure NO2 emissions in the most polluted locations. Thus it would appear that the levels of NO2 exceed the individual levels allowed by the Air Quality Directive. The Brussels Capital Region defends and says the measuring or sampling points are correctly located. The average of all the measurements at the sampling points in Brussels is within the EU limit. So the applicants say each sampling point is relevant. The Brussels Capital Region says an average is sufficient. The dispute is brought before a Belgian court, where the applicants ask the annulment of the Brussels Clean Air Plan. The National Court asks a question about the interpretation of the Air Quality Directive to the Court of Justice of the European Union. The Court of Justice gives this interpretation in order to make sure that the Air Quality Directive be interpreted, applied and enforced in the same way in all 27 member states. That answer goes back to the National Court, which applies it to the dispute at hand, and indeed the applicants win. Each measuring or sampling point must satisfy the maximum allowable emission levels of the Clean Air Directive. We see here that the legislative act of the European Union, the Clean Air Directive, comes in the form of a directive. What does that mean? Well, the member states have conferred competences to the European Union. They do so because the Union is the level at which member states can exercise their own powers in a more effective and efficient manner. For clean air, this goes without saying. Dirty air doesn't stop at national borders. So the care for clean air, just as clean water, sustainable energy supply and other environmental matters, have been entrusted to the European Union by way of conferral of competence. The Union exercises that competence through a legislative process involving proposals from the European Commission to the European Parliament and the Council of the European Union. They adopt the legislation for that purpose, with the majorities I already mentioned. The directive is a legislative act which posits a mandatory result to be achieved by the member states. The member states transpose the directive into national legislation, and it is national legislation which is applied to the EU citizens. EU citizens can also rely on that national legislation in order indirectly to enforce the result ordered by the directive. Next to directives, there are also regulations. Regulations are binding in every part and directly applicable to the EU citizens. The case shows that a uniform interpretation of EU law or EU rules is the essence of the task of the Court of Justice of the European Union. Without the Court of Justice of the European Union giving an interpretation requested by the national court of any of the member states, there would not be a uniform interpretation, but the risk that there would be 27 different interpretations of the same union legislative rule. The Google Spain case concerns the story of the Spanish businessman and Google. Mario Costeja González said that if you search for his name in Google, a link appears to an old newspaper article about money that he once owed. He paid off that debt ages ago, and the information is no longer of any interest. He claims he has a right to privacy, and therefore asks Google to erase the link from the search results. But Google refuses. Google says it has an economic interest in all search results appearing. The public also has an interest in access to the information. The right to information must be respected, Google claims. The dispute is brought before a Spanish court, the Audiencia Nacional. That court asks preliminary questions to the Court of Justice of the European Union in order to have that court interpret the relevant privacy rules and personal data protection rules of the European Union. The court answers to the national court that takes its decision in the case, and Mr. Mario Costeja González wins. The Schrems case concerns the story of the student and Facebook. Maximilian Schrems says, I have the right to the protection of my personal data and respect for my private life. Therefore, Facebook cannot just send my personal data to the United States, where, Schrems claims, these data are not protected in the same qualitative way as they are within the European Union. The Irish Data Protection Commissioner and Facebook, on the other hand, say to Schrems, your personal data on Facebook can be shared because the European Commission states in the Safe Harbor Agreement that the US ensures an adequate level of protection of personal data. The dispute having gone to the National Court, the National Court refers to the Court of Justice, the Court of Justice answers, and the case goes out in favor of Schrems. A single citizen can go to court and win against national governments, powerful companies, EU institutions. The cases Hungary and Poland versus European Parliament and Council concern the story of the EU subsidies and the conditionality mechanism. Hungary and Poland ask the annulment of the regulation adopted by the European Parliament and the Council of the European Union, imposing a conditionality mechanism on the receipt of EU funds, EU subsidies by member states. This is known as the conditionality regulation. The regulation establishes a conditionality mechanism to protect the union budget. The rule of law must be respected by member states receiving EU subsidies to effectively combat fraud and corruption related to these subsidies. In short, no rule of law, no payment. In their action for annulment, Hungary and Poland claim that the rule of law is just an ideal to be reached but cannot be specified in a legislative act, that is a regulation, that conditions the payment of EU subsidies to member states. The Court of Justice of the European Union rules that the values contained in Article 2 TEU, among which the rule of law, have been identified and are shared by the member states. These values define the very identity of the European Union as a common legal order. Thus, the European Union must be able to defend those values. The rule of law, a value common to the European Union and the member states, which forms part of the very foundations of the European Union and its legal order, is capable of constituting the basis of a conditionality mechanism. The Union budget is one of the principal instruments for giving practical effect in the Union's policies and activities to the principle of solidarity mentioned in Article 2 of the Treaty on the European Union, which is itself one of the fundamental principles of EU law. The implementation of that principle through the Union budget is based on mutual trust between the member states in the responsible use of the common resources included in that budget. Sound financial management and those financial interests are liable to be seriously compromised by breaches of the principles of the rule of law committed in a member state. The European Parliament and the Council of the European Union win the case, but the case shows how rule of law and the value of solidarity are linked to one another. Member states and their citizens will only be ready to uphold the solidarity between richer and poorer member states when they are assured that the subsidies granted to a receiving member state will be used for the purposes for which they are granted. And if that is not the case, that then there will be an effective enforcement in court against fraudulent practices in order to obtain the result that the subsidies will be used for the purposes for which they are granted. It shows the link between these values contained in Article 2 of solidarity and of respect for the rule of law.